Okay, this is the first of the small videos I'm putting up as part of our revision practices. And the questions I'm dealing with in this one are about whether non-discrimination is a fundamental right, why it's not treated as such, or as a standalone fundamental right in the European Convention on Human Rights, albeit it does have a standalone status in the Charter, and how we can usefully fit the Equality Act 2010 into our understanding with the rest of the course. And so those are the questions I've been sent and that I'm going to look at here, except I'm not, because the question, well, why is it not treated as a standalone right in the European Convention on Human Rights, whilst it is in the Charter, is one that I don't know the answer to. That seems to be a rather historical question about why the drafters of a particular provision made the choices that they did, and I can't tell you the answer to that. That moreover, the question, well, is non-discrimination a fundamental right? That we could say, well, our course is on fundamental rights and private law, and so the question of whether it's a fundamental right, in a sense, is potentially beyond the course, in the sense that one of our primary tests for whether something is a fundamental right is going to be the effect it might have on a state initiative that intrudes on that fundamental right, if it is fundamental, in the sense that calling it a fundamental right, one of the consequences of that designation is that it might mean that we have to have a particular approach to assessment of the justification provided by the state for a chosen initiative that intrudes on it. And so for us, we might be more interested in a sort of further question about, well, so far as this right exists, is it one that is a right against the state of such force that it's legitimate for the state to call on individuals to assist the state in fulfilling the duties that it imposes? Going further, does it actually impose a positive obligation on the state to create new entitlements in the private sphere? Even further still, does it operate as a fundamental right horizontally in the private sphere, so that private individuals actually can claim against other private individuals, hey, you are intruding on my fundamental right to be treated without discrimination. Okay, so why is that question of some importance? Why does it matter to us whether there is a kind of fundamental right in the private sphere or the like? Well, we could say, well, three ways in which it might matter. That one is in terms of how we would go about justifying the restrictions that the Equality Act 2010 potentially puts on other fundamental rights. So far as the Equality Act 2010 puts restrictions on other fundamental rights, for instance, manifestation of religion, we might be interested in, well, what sort of justification might the state have for putting those restrictions on manifestation of religion? Are those justifications entirely to be presented in terms of the public interest, some sort of public interest that's served by securing non-discrimination, or are those or are the justifications potentially ones that can draw on rights of others to be free from discrimination? So we've got a question there about, well, how would the state go about justifying those sorts of restrictions? Second question, that's one that we could give some prominence to, would be, well, what about justifying the non-restrictions in the Equality Act 2010? And what I mean by that is that the Equality Act 2010 clearly doesn't prevent private individuals from discriminating, for instance, when they're choosing who they're going to take a job with, or who they're going to buy their shopping from, or who they're going to form various family relationships with, and the like. And so there's sort of a gap in that the Equality Act doesn't put obligations on private individuals in some sort of private sphere. And we might be interested in, well, how far can or what sort of justifications can we rely on in order to explain that gap? Again, we could be saying, well, those people who are being discriminated against, the employer that I'm refusing to take a job with, that the supermarket that I'm refusing to go and buy my shopping from, that we could say, well, maybe they do have a right, but the justification for not enforcing that, not having a sort of a legal obligation on me to respect that, is to do with problems of enforcement or something like that. That alternatively, of course, we could see there as being some sort of conflict of rights here, that my right to self-express or the like comes into conflict with the right to be free from discrimination. But again, the question of whether there is a fundamental right to non-discrimination would be significant in how we structure that assessment of how do we justify this, how do we explain it, assuming we are going to justify it as opposed to critique it. Third sphere, which might make this question important, is of course our standard notion that if there is a fundamental right, that might affect how we interpret legislation, might impose an obligation to develop the common law if particular conditions apply. And so again, that we might have legislation like the Protection from Harassment Act 1997, which creates wrongs in relation to harassment. If there is a fundamental right to be free from discrimination, then that might affect how we interpret that provision. Similarly, we know that we've got torts like, or perhaps a tort to do with intentionally inflicting emotional distress. Whether we have to develop it or might depend on whether there is a fundamental right to or be free from discrimination. Now, of course, we start at the start with the notion that, well, in the European Convention, the non-discrimination right is parasitic in the sense that it's a right to no discrimination associated with the delivery of the other entitlements in the Convention. And obviously the Charter, EU Charter, has its standalone protection against discrimination, but there it's limited by the fact that the Charter only operates in the sphere of EU law. So the question of whether there's a sort of fundamental right to be free from discrimination beyond those two sources is a much more sort of normative question, I guess, about what ought the common law, constitutional law of the United Kingdom or elsewhere recognize such an entitlement, or ought there to be such an entitlement? And there we've got quite an interesting philosophical question that I think again risks going a bit, or stretching the envelope of the course, about if there is going to be a right to be free from discrimination. Well, what's it based on? Is it based on some sort of obligation of the state to secure basic goods that will help to people to live a good life? I think that's Taryn Caton's type explanation for the right to be free from discrimination, that it's to do with the state's obligation to deliver certain basic goods. Or is it something based more on dignity or freedom from stigma, or something which we can far more easily see as potentially being asserted against other individuals in the horizontal sphere? I hope that's of some help.